Hi, Sarah, and everybody else. I am so sorry that I can't be with you today, which is tomorrow for me. As you know, there's been a death in the family, and that's going to take us out of town tomorrow. So I'm recording these comments, and in hopes that they'll add at least something to the what I'm sure will be scintillating conversations that you all have. I'm really sorry to miss those. So let me also say that I'm fighting a flu, and just recording this on my laptop, and so if I have to, I'll pause it if I have to cough or something like that. All right. So let me begin with some general comments, since I will have missed the preceding discussion that you've already had by this time, and of course we'll miss the subsequent discussion. I thought I would offer some general comments in addition to the comments on Chapter 2. So this is, Sarah, as you know, I admire your work. I have since, the 2002 article of yours came out. And in particular, what I see as the greatest value added for historians is, on the one hand, the way that you bring voting rights and proxies and cumulative voting and associated issues, preemptive rights, etc., into a common framework. I, as you know, have done a fair amount of work on voting rights. I know something about the history of proxies and cumulative voting from my teaching, if nothing else. But I have to say I didn't really quite understand, in particular, the voting rights, proxies, cumulative voting connections until I read your work. And so I think that's a huge plus. And I also like the way you draw an explicit analogy between the civic polity and the corporate polity. That is something I've done on a smaller scale in my own work, as you know. It's something that some people don't like, and so you might get a bit of pushback on that. But I think it's really the right way to go. I think it is the right analogy. I think people thought in those terms back in the 19th century. So some general suggestions. One, I would encourage you to make more extensive use of the of the secondary literature throughout your book to clarify, on the one hand, contributions of others, and on the other hand, your own distinctive contributions. That sometimes gets a little muddled up. So I'm thinking of classics like, of course, Edwin Dodd's American Business Corporations until 1860. He was really comprehensive in the number of bases that he touched, and is still, I think, a very useful work. But I'm also thinking about more recent works like Julia Ott's book, When Main Street Met Wall Street, Robert Wright's Corporation Nation, and a long article by Harwell Wells, a legal scholar, called A Long View of Shareholder Power. It would be useful, I think, to not only bring those in to buttress your argument, but also to show where you disagree, if you do, with those positions, or where you agree with them. Secondly, I think you need to add an introduction, probably to part 1, that just lays out the basics, explains how corporations were created by special acts, through governed by enabling legislation, if that's the right term, the legislation that applied to corporations but didn't create corporations, general incorporation laws, and finally, of course, the common law, which is one of the more difficult things to figure out sometimes. But the reader really needs to know, sort of what the process was and how that changed over time. In the course of that, I think you need to also lay out briefly at the beginning of part 1 the range of issues that were spelled out in charters or statutes, and what happened if they were not specified. So, for example, voting rights is one. There was sort of widely accepted a common law default, but that's still, I guess, subject to further exploration, some of which I might be able to do myself, I'm hoping to. But in any case, if voting rights were specified for elections only, as they were, for example, in the 1849 Pennsylvania manufacturing law that you cite, then the common law, or let's put it this way, then those voting rights did not apply to non-electoral issues. And that much is clear to some degree in the secondary literature, and you might cite something along those lines in your chapters, but it's certainly clear in the minutes of shareholder meetings, which I've read a lot of and plan to write about when I get back to my book. Hold on a second here. I don't know what that message was. I hope you didn't see it. Also in this introduction, making the trends over time clear and the numbers of corporations chartered, for example, the shift in corporation practice from special acts to general incorporation, how that played out, etc. You can base this whole introduction on secondary literature. I don't think it would take much doing, but the reader really would be helped, I think, by having that kind of overview up front. Thirdly, I would encourage you, and this is probably maybe not what you want to hear, I would encourage you to consider changing the order of the chapters in part 1. One relatively simple alternative would be simply to begin with voting rights, then proxies, then collective action and cumulative voting. Voting rights are foundational, and it strikes me as kind of a 21st century perspective to begin with proxies. Voting rights were foundational. There's no point of a proxy if you don't have voting rights. So it seems to me that, at least from the viewpoint of a 19th century historian, voting rights are the place to start. So I hope you'll consider that. Another alternative, and this would be more work, I'm sure, and I'm not sure what it would look like exactly, but an alternative would be to organize part 1 in chronological chapters that integrate the 3 topics, or at least initially the 2, voting rights and proxies, and then bring collective action in a bit later, maybe. The problem is I don't know exactly what how those chronological, whoops, hold on a second. This is where we pause. Okay, sorry. I don't know exactly how those chronological chapters would be organized, which is to say, I'm not sure what the periodization is in your existing chapters. So that at least is worth thinking about. And if you were to reorder them to begin with voting rights, then in each of those chapters, I would encourage you to try and make clearer what the periodization is over the century or so that those chapters cover. And finally, I found myself wondering at a number of points how proposals to move to federal incorporation periodically surfacing in the public sphere fit into your story, or federalism more generally. There was certainly a tremendous amount of competition, economic competition among the American states, which affected how they dealt with corporations. Now, I'm thinking here beyond the charter mongering that we all know about. I think it affected their propensity to incorporate companies. And I'm just wondering if you can see a way to clarify whether you see, in particular, the failure to move to federal incorporation as part of your story. Because, as we all know, it is still the most distinctive feature of American corporate governance and corporate regime, that most of our legislation is state level. All right, so let me move on. A couple of comments about Chapter 1, the case of the Fitchburg Railroad controversy. Throughout this chapter, I would encourage you to make clearer what were allegations, and in the case of the Fitchburg Railroad, what were substantiated in the Phillips trial. There's also a discussion of proxy abuses later in the chapter. A lot of this is allegations, not sure what to make of that or how well substantiated they actually were. Where the Fitchburg Railroad Company is concerned, its annual reports are available on Hathi Trust. So I would encourage you to take a look at those. In 1887, just before this annual meeting, the company had gone through a massive consolidation process that gave it a continuous line of transit from Boston to Troy, New York. Its share price had been falling, you say, over the previous year. I'm wondering what the annual reports reveal about its actual financial condition. You later refer to its poor financial performance, but I'm just wondering if you mean more than just a falling share price, or that's all you mean there. Also, where the Fitchburg case is concerned with proxies, this is, to my mind, one reason to reverse the order of the chapters, because shareholder railroad votes, as you know, were capped in Massachusetts at 1/10 of total votes until 1906. That's obviously relevant to the story of the officers trying to spread out the proxies, and also Massachusetts capped the number of proxies that could be cast by an individual, and capped at an even lower level the number of proxies that the officers could cast. So I think it would help to switch the order of things, and then look again at your phrasing about the use of proxies. I won't say anything more about that because I know my time is elapsing, and I do want to say something about the shareholder voting rights chapter, which is, of course, the one I'm most interested in. I admire the scope of this chapter, encompassing, as it does, the early variety in voting rights, shareholders' preemptive rights, the general incorporation process, although at this point in your chapter the organization starts to falter, the move to one vote per share rules over the course of the 19th century, and then the addition at the end of non-voting shares. That's nicely comprehensive, and I congratulate you on that. Here too, I think you can make broader use of the secondary literature. In particular, I think you rely too much on Eric Hilt's studies of New York, because they focus either on New York, which is, I think, a special case, as he says, on the cutting edge of governance innovation, but not necessarily a good basis for generalizing. And also some of his work focuses only on manufacturing corporations. So there's other stuff that you can pull into the story more so. Bodenhorn's stuff, in addition to, of course, my own. Secondly, I think you can make use of the data that Scylla and Wright have put together, at least on the numbers of corporations, whether you do that in this chapter or in an introduction to part 1. However, I do want to caution you to be careful in using their data on voting rights. There are some 1,200 records, companies that they've misclassified as one vote per share that should be prudent means. So I'd be happy to talk with you about this. Just be careful you don't take their numbers at face value. It's a tremendous amount of work they've done. It's incredibly valuable, but that seems to have been the result of a fuzzy understanding, shall we say, of what I meant by the term prudent mean voting rights. All right, also in this chapter, I think you should take care to clarify that managers, that is directors, were shareholders themselves in the 19th century, as a rule, less so maybe by the end of the 19th century. So disputes between shareholders and directors in the antebellum period for sure were disputes among shareholders. This is one point that Harwell Wells is good at making in his 2015 essay. Excuse me, I'm going to pause. Okay. I better take a bigger break. Okay, I'm going to try again. Apologies for the interruption. I'm not, by the way, editing this video, so it's kind of, what you see is what you get. Okay, so back to Chapter 2. On the move away from graduated voting rights toward one vote per share voting rules, I don't really buy the argument that voting with graduated scales was too complex. I think people in the 19th century were pretty used to dealing with complexity. And also, I want to show you something here, which is, whoops, let me see if I can get this up here in a way that you can see. This is, you can see that? No, you can't. Okay. So this is a list of shareholders with the number of shares and the number of votes that they have. This is the South Side Railroad, 1849. It's a document from the Virginia Polytechnic Archive, big Southern Railroad archive. I think this is probably just the way they did it. They knew who their shareholders were, they knew how many shares they had, and they knew what the voting rights were, and so they just wrote the little numbers down. And the individual stockholders, too, knew how many votes they had. So I just don't think that's a reason. I have my own thoughts about the movement away from one vote per share or toward one vote per share, which I'll be happy to talk with you about, but I won't bother going into that now. So other than this, I have a series of just minor points, and I know I'm running up against my time limits here. So let me just mention the following. Your discussion of the Bank of North America. I found this very interesting. I learned things about it that I hadn't been aware of. I think you need to explain to the reader the mess with its charters, congressional and state charters, and so on and so forth. You mentioned them in passing, and it won't make any sense to the reader without some background. I wasn't aware of Tench Cox's reports on how things actually worked at the Bank of North America, so that was, to my mind, a very interesting bit of background. Page 5, you say that many types of voting rights are in use, which, yes, I think that's pretty much everybody agrees to that statement these days. But then you also add that there was considerable debate and acrimony over voting rights, voting schemes that translated investment wealth into governance power. The considerable debate and acrimony, I think maybe that needs to be tempered a little bit, an overstatement perhaps, unless you have other examples besides the Bank of North America, because I really have looked high and low for discussions of the proper voting rights, and they're few and far between, I must say, which is interesting in itself. Another question I had is whether you've seen any awareness in the documents of European models, the Bank of England, for example. Bank of England gave shareholders one vote per person, or members as they were called. Is there any sense of that? I'm so sorry. I have to pause again. Okay, I am going to say just a few more words before my throat gives out. I bet you all are very glad that I'm not there in the room with you. So overall, this is a very exciting piece of scholarship that you have in hand, Sarah, especially, as I said at the outset, for its ambition to bring voting rights, proxies, et cetera, into a common framework and indeed a framework that highlights analogies between civil and corporate polities. What you're proposing, I've, as you know, done this some in my own work, but you're proposing to do it on a much broader scale, and I compliment you on that. Again, I apologize for not being able to participate in person. If you have any questions about this, of course, any of you, I hope you'll feel free just to email me. And Sarah, you and I can catch up once the dust settles. Okay? Thanks. Sorry. Bye.